Good morning again. My name is Laura Duarte. I'm the NCP Coordinator Assistant. For me, it's a pleasure today. I'm glad to be the moderator of the panel Duties for the Rights of Future Generations, the Promise of International Court of Justice Advisory Opinion. Today, this is going to be a really great space because we're going to show you how we are trying to join two different forces that complement each other. So the first one, on one side, we have the experts on the field that had already experienced taking steps forward to get advisory opinions accepted. And on the other side, we have the young activists with regards to the rights of future generations. And this is also always on the sides of climate change. So right now, I would like to start to explaining to you a little bit of the panel really brief. So at the beginning, we're going to have one of the NCP consultants, that is Riet. He's going to start briefing some snapshots of breakthrough climate cases and key lessons, and he's going to focus also on the litigation and the importance of the international dimension. Then we will have Alyn Ware, that he will also get deep on the focus on the importance to take this in a structured way to higher institutions. Then we will start with the young voices. So we will have Nicole and Ponce and Solomon Yu from the World Youth for Climate Justice Youth Movement. And we're going to finish with Olivia Richard, Samira Bennnelli. So they're going as students for a master's degree in climate change and future generations, and legal transitions. They're going to tell us their experience with the I Am Climate Justice movement, and also they're going to explain us a little bit about one youth report that is taking really good chances to get to an advisory opinion on the assembly at the UN. So right now, for me, it's a pleasure to introduce to you Ron Van Riet. He is currently an independent consultant and on issues related to arms control, sustainable development, and climate and energy. Right now, he's a senior advisor to the World Future Council. And Rob, you have the floor.
Thank you, Laura, and I hope you can hear me. So, yeah, thank you very much for giving me this opportunity. I'll try to be as brief as possible because we have a lot of great speakers. And so in terms of setting the stage for today's panel, I just wanted to very briefly look at what is happening with climate litigation, which is relevant to the theme of going to the International Court of Justice, but also the broader theme of this conference. So I'll just focus on three dimensions. And the first is a simple statement that we live in the age of climate litigation. The total number of climate change actions issued across the globe doubled between 2017 and 2020. Last year, over 1,500 climate cases were filed in approximately 37 countries. Now, important to note, these cases are, of course, not all the same. Rather, they cover a range of claim types and different plaintiffs. But one thing is crystal clear, and that is that courts have an increasingly important role to play in this space. Now, the second point I wanted to highlight is, what does this mean? How is it having an impact? Now, what it means is that companies, governments, and industries are now facing unexpected judgments with serious implications for business operations and/or state policies. A recent report found that almost 60% of non-US cases in 2020 had favorable outcomes to climate change action. Now, in some of these instances, this goes quite far. And I just wanted to offer two well-known examples of this. Both happen to come from my birth country, the Netherlands. The first is in 2019, the Dutch Supreme Court ruled in favor of the NGO Urgenda against the Dutch government. The court recognized that the government owes a duty of care to its citizens to protect the right to life and the right to respect for private and family life. The court concluded, importantly, that those obligations require the governments to take steps to reduce carbon emissions consistent with limiting warming to an average of 1.5 degrees. That decision, in turn, led to a commitment by the Dutch government to reduce the capacity of its remaining coal-fired power stations by 75% and to implement a €3 billion package of emissions reduction measures by 2020. Now, that is a clear impact in response to the ruling. Second ruling quickly to mention here is that in yet another landmark decision just 2 months ago, a Dutch district court in The Hague ruled in favor of another Dutch NGO, the Dutch branch of the Environmental Defense Fund, and found that Shell, the oil giant, had a similar duty of care, like the Dutch state, and is responsible for carbon reduction, and ordered the company to cut greenhouse emissions by net 45% by the end of 2030, exactly as the plaintiffs requested. So I mentioned these two, and of course there is a wealth of others, to illustrate that these rulings can force policy changes and business operations. And in some other instances, some of these rulings stop specific government or corporate plans to extract fossil fuels or cause other irreversible destruction to natural habitats. But what it also means is that courts are considering, applying, and fleshing out some core environmental protection and human rights principles, including intergenerational equity and justice. Finally, the third point, and I'll end there, is that, of course, there is a limit to what these rulings can do. They go not beyond national borders. And it's also often the response from governments or corporations in the docket to say, there's only so much we can do. This is a global problem requiring global cooperation. It's not just up to us. And that's exactly where, of course, the International Court of Justice can come into play. I'll leave it there in the interest of time, but thank you very much.
Okay. Thank you for your remarks. So this way we're going to continue with Alyn Ware, who's next to me. He's a peace educator and international peace and disarmament campaigner. He's co-founder of and global coordinator of the Parliamentarians for Nuclear Non-Proliferation and Disarmament, Peace and Disarmament Programs Director for the World Future Council, and he's today with us. So Alyn, is after you. Mm-hmm.
Thank you very much, Laura. Do we have the presentation up on the screen behind? Yes, thanks. So come closer. It's a great honor to be here to speak about this exciting initiative to take a case to the International Court of Justice on the legal responsibility to stabilize the climate for the protection of current and future generations. And I'm going to pick up where Rob van Riet left off, where he mentioned the importance of taking legal action at the international level in order to provide more of a even playing field and supporting what's happening in the national courts as well. And so I'm going to look, next slide please. I'm going to look a little bit at the lessons that we learned from a case which I was involved in, which was to take the issue of nuclear weapons to the International Court of Justice, talk about the value of an advisory opinion of the International Court of Justice. Can we get a climate case to the court, and whether it looks likely we could win the case? These are very important. Next slide, please. So the first thing of the value, next slide, please. Thanks. Next thing is value of an ICJ advisory opinion. And this is important because a lot of people don't realize that an International Court of Justice advisory opinion is a real case. It's not like just going to your lawyer and saying, can you give me advice? It is one of the principal cases that the International Court of Justice can undertake. Firstly, the authority of the International Court of Justice. Every country that's a member of the United Nations has accepted that the International Court of Justice is a principal judicial organ of the United Nations and therefore of the world. All members of the United Nations are, by being members of the United Nations, are parties to the statute of the International Court of Justice. So it's got a very important place in both the global legal and political systems. Secondly, as I mentioned, an advisory opinion is a legal case. It's not just an opinion. It's called an advisory opinion because it's different from another type of case, which is a contentious case. A contentious case is where one country may take another country to the court to resolve a legal dispute between those two countries. whereas an advisory opinion is a question about a matter of international law that's asked by an authorized United Nations organ or specialized agency. So when the court gives its opinion, it's an authoritative determination of what is the law pertaining to that question asked. Next slide, please. So next, can we get the case of climate change to the International Court of Justice? As I mentioned, for an advisory opinion, it takes an authorized organ or specialized agency of the United Nations to ask the question. So you have to get a decision through that organ or agency. And that can be difficult if you're taking a contentious issue. But we demonstrated with the nuclear weapons case that you can get a contentious issue into the court, even if you're up against very powerful countries. We were up against the most powerful countries in the UN. The P5 members with veto power in the Security Council all had nuclear weapons. They were all against us, but we managed to beat them. And why? Because we went through the UN General Assembly, where every country member has one vote. So the Marshall Islands, Solomon Islands, Costa Rica have the same vote as Russia or the United States, and we could get a majority against nuclear weapons. And that's what we're looking for also for this particular case. So I believe it's possible, we can do it, we can get a majority in the UN General Assembly, and then would use the UN General Assembly to follow up once we get a decision from the court. Next slide, please. And finally, can we win the case? Well, the interesting thing about the International Court of Justice is it takes a very broad approach to the law and to the applicable facts and evidence. So under the statute, the sources of law, it can go to treaties and conventions, but also to international custom, general principles of law, and judicial teachings and decisions. So it's got a really broad area that we can bring in customary international law, including, for example, law protecting future generations, which is only slightly in treaties, but is much, much more broadly in international custom, general principles, and now other teachings. So there's a lot more sources of law that can come in that will be able to help this case. And secondly, the court is very open to considering the wide range of facts, scientific evidence, and testimonies that are presented to the court. So it's pretty open to what we can present to the court. So in the nuclear weapons case, it was testimony from the mayors of Hiroshima and Nagasaki and the victims of nuclear testing in the Pacific that was most influential and really brought about the conclusion of the court that the destructive power of nuclear weapons cannot be contained in time or space. So I think that we have a good case for being able to get the case to the court and winning the case. And now to tell you more about how that's happening, we have those who are leading the campaign, which is World's Youth for Climate Justice, supported by the Normandie Chaire for Peace. Thank you.
Exactly. So thank you, Alyn, for the whole road you picture for us. And right now we're going to start with the young voices. So I will give the floor to Solomon Yu. He is from the Solomon Islands and he holds a bachelor in law and politics, and he's dedicating his life to addressing climate change and inequality. So right now he's going to focus and brief us on the World Youth for Climate Justice movement. Solomon, we hear you. Thank you.
Thank you very much, Laura, for the kind introduction. Good evening and good fellow afternoon to you all from the Blue Pacific. It is a great honor to be joining you all here from outside of the world, although not cold as your end, but pretty much warm as well. Today, I'm really privileged to represent the World Youth for Climate Justice alongside my colleague, Nicole, on the ongoing youth campaign to take the biggest problem of our generations to the highest court in the world, the International Court of Justice. So to begin with, in spite of the climate catastrophe globally, the desperate need for more efforts to embrace the climate crisis is still lacking. This is especially true for us here in the Pacific, which the threat of climate change is existential. We are no longer able to enjoy the full enjoyment of our basic human rights, such as right to clean water and sanitation, right to health, right to food, and the rest. But if you haven't noticed, in the backdrop of failing multilateral process, there is a proliferation of climate cases in national and regional courts all around the world, as alluded to by Rob. Yet, the world's highest court, the International Court of Justice, is still silent on the matter of climate change. We, the youth, we recognize this powerful role that the International Court of Justice can contribute in the climate crisis. In 2019, a group of law students from the Pacific Island countries have built upon the initial attempt of the Palau government in 2011 and launched an ambitious campaign to seek an advisory opinion from the United Nations General Assembly on climate change and human rights with framing. The campaign evolved beyond the classrooms of the Pacific region, with young people from all over the world coming together to form and unite under the banner of the network organization, the World's Youth for Climate Justice. The network is a support and learning center where campaigners from regional fronts share information, resources, and best practices as we work towards this common goal. The youth interest in the International Court of Justice Advisory Opinion campaign is founded on the unequivocal fact that in the climate catastrophe, it is the youth and the future generations who will stand to lose the most. What the youth are precisely wanting the ICJ to clarify is whether states have obligations under international law to protect the rights of future and current generation from the adverse effects of climate change. ICJ being the right international forum that can hear great evidence of law and fact that will help deliver a verdict that could assist in paving the way for the development of law that can help, among many other things, advance the development of law, unblock jurisprudential roadblocks, remove room for real doubt on climate science, and most importantly, form public consciousness around climate change. Although not a panacea, nor a replacement for ongoing climate negotiation taking place in international treaties, we believe the ICJAO is a well-justified catalyst for more ambitious climate action.
Thank you, Solomon. So right now we're going to continue with Nicole and Ponce. She's co-founder and coordinator of I Am Climate Justice Movement, research fellow to the Normandie Chaire for Peace, and a graduate to the Juris Doctor from University of San Carlos in the Philippines. Her work is focused on using law as a tool for social change, especially in the field of climate change actions and human rights. So right now she's going to focus on the intergenerational equity. Nicole, we hear you.
Thank you so much, Laura. So in relation to what Solomon said, in our campaign for an ICJAO, we want to emphasize how human rights can and must play a part of the solution in addressing climate change. However, at present, there is no general international law instrument which defines the core elements of intergenerational equity, and its legal status is still very controversial. The status quo is quite problematic, especially because there has been evidence and quite overwhelming of the application of the principle in international and domestic proceedings. It is well known that the ICJ in its advisory opinion on the legality of the threat of use of nuclear weapons has referred to the need to protect generations unborn. And the Gobet-Chokova-Najmor project, wherein Hungary invoked the concept of preserving species for future generations as a moral obligation, and the concept of trusteeship over the Earth's resources. In the judicial front, there has also been recent rise of court cases brought by and on behalf of minor plaintiffs and future generations, such as the case filed by the 16 children against 5 countries before the United Nations Committee on the Rights of the Child, and the case lodged by the group of Portuguese youth at the European Court of Human Rights against 33 states. So these are just to name a few. There is even more overwhelming state practice, as we have witnessed in a number of domestic proceedings and environmental law and policy. Take, for example, the case of Minor Soposa versus Pagtoran. It is the first and only Philippine case to date which deals with the issue of how to value natural resources, not only for present, but also for future generations. It is also one of the first of its kind to rule on the issue of the legal standing of generations unborn. And also in the case of Mehta versus Kamal Nath, the Supreme Court of India recognized the need to balance the competing claims of the present generation for development with those of generations to inherit a healthy environment, which is known as the public trust doctrine. So despite the application and reference by many international and domestic courts of the principle of intergenerational equity, in which a utility of rights is grounded, it has not been expressly recognized as customary international law by international courts and tribunals. Now, the ICJ, as the highest court in the world, is the right forum to set things right by endorsing that intergenerational equity principle is a customary international law, and then to connect it to state obligations to protect the rights of the current and future generations from the adverse effects of climate change. An advisory opinion on climate change and human rights can serve to cement the status of intergenerational equity as customary international law. And as we are racing against time to prevent climate change from exceeding global tipping points, there must be no room for ambiguity on state obligations. Marginalized communities who are suffering disproportionately from the impacts of climate change must be ensured that their human rights are not discounted, with wealthier nations upholding their commitments to developing countries, especially in accordance with their obligation to the Paris Agreement. And of equal importance is the need to clarify and cement the status of intergenerational equity as customary international law, where the ICJ is the best forum to do so. Thank you.
Thank you, Nicole. So right now we're going to continue with Samira and Olivia. The floor is going to be first to Olivia. She is currently a master student for future generations and legal transitions in Sciences Po Rennes. And right now she's going to tell us a little bit about her experience at the Normandie Chaire for Peace as intern and with the ICJ program.
I'll be talking first. My name is Samira Bennnelli, and as was said before, I'm one of the students on the program, graduate program of Future Generation and Legal Transition. I'm honored to be part of this symposium and to hear and talk to so many people whose work I admire. I will try to be as brief as possible because I know that we don't have much time. So I had the opportunity to work as an intern at the Normandie Chaire for Peace with another student, Olivia Richard, who is by my side. And I was able to work on many of the research line of the Normandie Chaire for Peace, but one of my principal focus was the research line on climate justice, and particularly the campaign, I Am Climate Justice. This campaign was born from an initiative of Antonio Oposa, Sir Antonio Oposa, and through his initiative and some of his cases, he was able to present it and show it to many experts. This I Am Climate Justice campaign, who consists to also have an advisory opinion. And he was able to bring around him many experts, and as we said before, young people, such as Nicole and Solomon, who talked just now. So just as Nicole and Solomon said before, with this, they took the initiative such as the World Youth for Climate Justice, and they were able to take this idea of seeking climate justice and formalize it around the idea of an advisory opinion that will be brought to the International Court of Justice. The chair to the Normandie Chaire for Peace is actively working through its I Am Climate Justice campaign with the same will and closely related to the WYCJ, with a focal lens on the right of future generation and human rights. We believe that if there is no greening of human rights, there will be no human rights in the future. That's why the chair is working actively on this research line. Through this ambitious project, we also want to have a confrontation with the International Court of Justice to try to define and clarify international law, and try to show a willingness to create a link between human rights and environmental law. And that's why a legal report was created by the WYCJ, and we're able to participate in it. And my colleague Olivia will talk more about it.
So thank you, Samira. Hello, everyone. I'm very pleased and very honored to be here today in Marseille as a speaker at this international symposium on peace with nature. So as Samira and Laura has just said, I am Olivia Richard, also a French student at Mrs. Emily Gaillard master degree. And I also did an internship at the Normandie Chaire for Peace at the same time as Samira. And I'm going to talk to you about the World Youth for Climate Justice report. Indeed, during our internship with Samira, we met Jules Schnackenberg, who is part of the WYCJ campaign. She invited us to contribute to the WYCJ's expert report, which we co-authored with about 20 young climate change activists. They are students from 8 different universities from the Netherlands, the United States, the UK, and even from Australia. It was a report about climate justice, preservation of environment, and respect of the human rights. So more specifically, the objective is to bring the voice of youth to the table and to encourage the International Court of Justice to take up the issue of climate justice. It also aims to provide a basis for academics and law students to think about the impacts of a possible adversary opinion, as well as to analyze its legitimacy on both legal and social sides. So, to be brief, the report also includes reflection about the Paris agreements, the world juridical system of human rights, and also reflections about the appropriate legal tools for climate action. So you can imagine it was a great opportunity for us as young people to contribute to this great collective work. And it was also an opportunity to put into perspective and apply what we are taught in our master degree, Future Generations and Legal Transitions, including the transgenerational approach to human rights. I will try to make it very quickly. In my part of the report, so the title is Transgenerational Approach of Human Rights. Under the guidance of Mrs. Gaillard, I explained why it is crucial to change the paradigm and to consider that future generations have rights and that we would have even more duties towards them. I insisted on the situation of great vulnerability in which future generations find themselves, as human activities are increasingly destructive to ecosystems, and environmental degradation and the overexploitation of natural resources are accelerating. This new prism is that to say, assuming the existence of rights and duties towards future generations would make it possible that for each project, each decision or action, it will be necessary to ask the question of the effects and impacts it will have on future generations. So if you are interested, you can find the report online on the WYCJ website. So that's it, and thank you very much for your attention.
Thank you, Olivia and Samira, and thank you also Alyn, Rob, and Nicole and Solomon. So there you see the global picture of this movement and this joint forces of experts and young people, and the importance of the intergenerational vision to take this lead. So right now I'm going to open the floor to some questions here. So I will give the word to Alyn Ware that is next to me.
Comment just before the question. This is just one comment before the questions, just for everybody to know that World's Youth for Climate Justice and Normandie Chaire for Peace are organising a series of webinars, which you're all welcome to join, to explore the different aspects of taking this case to the International Court of Justice. We've had 2 so far, we've got some more coming up, and usually we hold the webinar in 2 sessions. One session to suit those in the time zone of Asia Pacific, and the other one to suit those in the time zone of the Americas, Europe, Europe, Africa. So you can get information from any of us, and we invite you to join, where we go into more depth on all the issues, the legal aspects, the questions to be asked, the political process, the implementing the decision once it comes out. All these are important aspects of this wonderful initiative. Thank you.
Alyn, maybe you can just quote the person that you invited in the latest webinar, the names of the participants.
Most recent one. So we were looking at what question and how to get the case into the UN General Assembly. So for example, we had Maria Espinosa, who's the former president of the UN General Assembly. So she has really good experience at that. And I actually can't.
That's right, that's right.
Oh, and we have on sources of law that could be used. We had one of the directors of the database on climate litigation from the Sabine Law Center in Colombia. And then we had a couple of other legal experts as well.
Donc, Alyn, Ware et Rob Van Hayet animent cette ligne pour la Chaire Normandie pour la Paix sur le WYCJ, qui était l'une des grandes présentations et des grandes majeures lorsque nous avons créé la Chaire Normandie pour la Paix. Ils le font merveilleusement bien avec des très hautes personnalités, font le lien avec le pont intergénérationnel. Mais pour avoir the global picture, comme l'a dit Laura, il faudrait donner la parole à professeur Forman pour présenter le First Tony Opposa Moot Court, qui a eu lieu à Hawaï lors du précédent congrès mondial de l'UICN. I give you the microphone right away, okay?
Before I respond to Emily's invitation, I'd like to congratulate the organizers of this event for not just talking about future generations, but including representatives of future generations on the panel, both via Zoom and in person. I do have a question for Alyn, but Emily wanted me to share a little bit about the inaugural Opposa Intergenerational Moot Court, which was held at the IUCN World Conservation Congress in 2016 in Honolulu, where the question posed was this very question: should the International Court of Justice issue an advisory opinion on the duties of states with respect to future and present and future generations to deal with the climate crisis? And I'd be happy to speak with others more about that event. Alyn, typically, and for any of the youth here, typically when people think about the International Court of Justice, they think about it as a forum for the states to share their views. I was wondering, as we get ready for the World Conservation Congress, is there a possibility for organizations like the IUCN that have recently involved Indigenous peoples organizations as having voting rights? So it's an unusual institution in that regard. Can organizations besides the states themselves be invited by the International Court of Justice to share their views?
Thank you for the question. So firstly, it's a UN organ or specialized agency which takes the question to the court, asks the question. Once the question is then received by the International Court of Justice, it sends an invitation to all parties to the statute, i.e. all UN members, which is member states, to participate both in the written and oral process. The court, the ICJ, does have an option to invite an other organization, an international organization, that to contribute evidence if they deem that necessary, but the general practice, they have not done that. So the general practice for us as civil society to get testimony, to get evidence into the court, is to work with like-minded countries. And that's what we did with the nuclear weapons case. We had a number of countries like Costa Rica, Malaysia, New Zealand, who were very open to the evidence that we wanted to be presented, and they included that in their presentations, and to having witnesses. So for Japan, they brought the mayors of Hiroshima and Nagasaki. For the Marshall Islands, as well as having the ambassador, they also had one of the victims of nuclear testing from the Marshall Islands. So we were able to get, as I said, the evidence and testimony in through like-minded countries.
Thank you, David. Thank you, Alyn. So right now we have a second question in the public, so I give the word. Yeah.
Yes, I have also a question for Alyn. I would appreciate more arguments about advisory opinion as a case. Let me be shortly the devil's advocate, but I teach to my students that in a case you need two parties in a formal way that have legal personality in international law. And the instrument also is not binding in an advisory opinion. In a judgment, the judgment is binding for the two parties. The advisory opinion, as for me, it's the instrument is not binding. The content is binding, but not the instrument. And since for lawyers and for states, they would say, but it's not a binding instrument, its form is more important than content. Would it not be more effective to convince one state, Tuvalu or Kiribati, to bring a real case to the court, an interstate course? Thank you.
Thank you for the question. We actually did look at that question, whether to take a contentious case or an advisory opinion with regards to the legality of the threat or use of nuclear weapons. And we determined that a contentious case would be much more limited, because a contentious case only applies to the state's parties in that specific case. Whereas an advisory opinion is a determination of the status of an international legal question, which is applicable universally. And so in this case, the nuclear weapons, and I think similar with climate change, we don't really want a case that's just about one country versus another country and what the responsibilities of each of those countries is. We want a determination that is universally applicable. And so while you're correct that the decision itself in an advisory opinion is not binding, what the court is doing is determining what is the status of law. So in essence, it's actually clarifying what law is binding on countries. Even if the decision itself is not binding, it's clarifying the nature of the law. And so that's very, very important. And that then, as I said, helps the international community to take forward these issues. So with the nuclear weapons case, the decision was that the threat or use of nuclear weapons was generally illegal, and that there is an obligation to pursue negotiations to achieve nuclear disarmament. And both of those, the two aspects of the decision, both of those have been very, very effective in advancing, firstly, the non-use of nuclear weapons and the acceptance by governments, particularly nuclear weapon states, that international humanitarian law applied to their nuclear weapons and their planning. That's been a big step forward. They didn't accept that before. And secondly, on the obligation to pursue nuclear disarmament, it's led to a number of initiatives follow up on that. We haven't yet achieved the elimination because it's a particularly powerful tool, the nuclear weapons, but we have got negotiations that have started, and we've also got a treaty on the prohibition of nuclear weapons that's emerged as a result. So I would say that in the climate case, an advisory opinion is a much better approach than a contentious case. But of course, they're not mutually exclusive. One could also take a contentious case alongside, if one wanted to look at the particular actions of a specific country or group of countries. But I would say the advisory opinion has a lot more possibilities of having an impact.
Je vais conclure aussi en disant et en rebondissant sur ce que vient de dire Alyn, on peut imaginer très bien un advisory opinion devant la Cour internationale de justice et à côté qui est aussi des campagnes devant les systèmes juridiques régionaux, devant la Commission interaméricaine des droits de l'homme, devant aussi, il y a déjà des actions qui ont lieu au niveau européen, au niveau des mécanismes de Genève, donc on voit bien qu'il y a une grande campagne, une grande mouvance à l'échelle internationale. Donc vous l'avez vu, on a l'immense honneur d'avoir Alyn Ware à la stratégie avec Rob Van Ayet. Donc pour les étudiants, vous savez que vous avez la possibilité de pousser cette ligne ICJ en France, de leur co-organiser aussi avec d'autres jeunes à l'international, et donc ça va vraiment prendre son envol cette année. Et c'est sur une idée originale donc du leader de la chaire, Tonio Posa. Laura, je vous donne la parole pour clôturer et donner les indications qui suivent.
Okay,
Merci.
thank you, Emily, thank you. to all the panel, to all the participants and speakers in the auditorium, and thank you for your endurance on the whole half day. Right now, we're going to have one small pause to have lunch, and we will meet again at 2 p.m. So for the Facebook Live and Zoom webinar, we will see you there 2 p.m. And in the cell, we're going to meet 10 minutes before, just to be on time. Thank you again, and have a good meal.